All right. Good evening, everyone, and welcome. Happy Tuesday. My name is Emily Newman. I'm the managing partner of Reddy Neumann Brown, together today with Stephen Brown, who's also a partner of our firm. And every week on Tuesdays, we bring you the latest immigration updates in the employment-based immigration categories. And so this week we want to talk about a new I-485 inventory report that just came out today. We haven't had one since 2018, so it's kind of nice to finally get some numbers to help us understand the visa bulletin. So we'll break down what information we were able to get from this new report and what does it mean, particularly for people in India that are stuck in the backlog for EB2 and EB3. Stephen's going to give you an update on what's going on with litigation, how you can fight back using legal action to resolve immigration delays, what kind of cases it works for, what we've got going on with our pending cases right now, what we're trying to accomplish, and give you kind of some tips on when is the right time to consider litigation. And then we're going to talk about concurrent H1B filings. This is what allows you to work for two companies or even more at the same time, as long as you have two approval notices. One is for concurrent employment. One can be full-time, the other part-time. They can both be full-time, combination of all these. So we'll talk about what are the benefits of doing that, but also some challenges that people face who are using this concurrent employment option. And lastly, we will get into transitioning from having a Cap-Exempt H1B to a Cap-Subject H1B. What is that process? What do you need to do? Do you have to go through the lottery? What's the timing look like? And all of those aspects. So getting back to this inventory. So we used to get an inventory every couple of months back pre-Trump. The last one we got was 2018, and you could literally check what your priority date was and look at the date and month of your priority date and see how many 485s were ahead of you in line. And then they just stopped publishing it. I know, Stephen, you did a Freedom of Information Act request to get that information. So I was kind of surprised to see it today. How about you?
Yeah, I mean, they're kind of fighting us. The 485 Freedom of Information Act FOIA that we filed was lengthy, but we wanted this as well as some of the I-140 data more broken down. But look, I'm all about getting this information out, whether it comes from my win or they've just decided to change their stance and get back to publishing it. This is good transparency so people can see what's ahead of them. And I think, Emily, you and I have been talking this afternoon because they did this. There was no pomp and circumstances, no email, nothing. It just, I got it in a Telegram group that I'm in that said it was published. Looked it up, and it's on the statistics webpage. But there's a lot of information to glean from this, especially for Indian nationals, and what the unfortunate backlog looks like and kind of what to expect moving forward. I mean, lots of already filed 485s, and that doesn't include anything. What we don't know, and I want to preface this, we don't know anything with what Department of State has. Anybody that is consular processing their 485. I don't think it's double this number, but it's certainly more than what we got from USCIS.
Yeah, so going back to 2018, I pulled that chart. It had a different format back then, and it was not in Excel, so I had to do some hand data entry there. But basically, as of July 2018, at that time, there were 15,826 I-485s pending that had a priority date before May 2010. So 2010 kind of was our cutoff date for a number of years. That lasted till 2018 before dates moved forward a little bit again. And then we don't have any data after that. So 15,000 we had pending. This was in July 2018. So there was an 8-year wait for many, many people in 2018. Fast forward 6 years, and now we have 35,507 EB2 I-485s filed and pending. These all have a priority date before January 2015. So we all know these are from the October 2020 visa bulletin, where the date jumped forward for EB3 to December 2014. We had all those downgrades. So basically the number of 485s that were pending going from 2018 to 2024 more than doubled in 6 years. That's definitely not a good sign. I mean, it's great that people are able to file the 485 and get those interim benefits and things. There's definitely positive to having that, but that number, 35,000, how long is it going to take to get through the already pending 35,000 before the date's going to move back to where it was in October 2020?
Yeah, I thought it was really telling. You know, I went through, and this data, like Emily said, is in Excel. So all you folks that are data people and analytics, statistics, whatever, you guys can probably figure out more from this potentially than Emily and I can. You know, we have 35,507 EB2 India, EB2 India 485s with 2014 priority dates or earlier. That's a lot. It's not going to move anytime soon. EB3, 19,481 with the same date range. EB1, that's why we're seeing the retrogression, 16,453. And again, we don't know what Department of State has. Again, I don't think it's double this number, but there's probably a good handful of thousand, that, you know, a couple thousand or so with Department of State. So,
yeah. And so a few things about the inventory data. These are actual pending 485s, which means it does include dependents. So we actually know how many dependents are out there. This is the total population of pending 485s for the main applicant on the I-140 plus all of their eligible dependents. And the hard thing is, every year, we don't have an exact number of how many EB2 485s are going to be approved from one year to the next. It does vary year by year. We know that the minimum is we have 140,000 green cards available, 28.6% go to EB2, 7% of that go to India, EB2. But if we look back historically, we know that there has been spill down from EB1, unused green cards from EB1 come down to EB2. And when those are not used up by the rest of the world, they go to the country that has the most backlog, which is generally going to be India. And we can't really look to the last 2 or 3 years at how many green cards are approved every year in EB2 India, because that number is way higher than any other time because we had all of the family-based spillover. So what we really need to look at is pre-COVID numbers, before the family-based spillover started happening. For those couple of years where EB2 India was just backlogged all the time, how many people actually got their green card in EB2 India every year? And looking back for those 5 or 6 years before COVID, every year, an average of 4,200 people got their green cards in EB2 India. We have 35,500 pending cases, and we're going to assume about 4,200 are going to get their green card each year. When you do that math, that comes out to over 8 years. So we have 8 years worth of pending applications. It's going to take till 2032 before we finally make it back to January 2015 or to December 2014. That's definitely not a good sign.
And I see it popping up here on the chat. You know, could there be double filings for the same candidate in EB2, EB3, and maybe EB1? Absolutely. I don't think it is an overwhelming number. I think it is definitely more than a statistical anomaly. I'm sure there are people who are waiting in both lines or all 3 lines. potentially even, especially, you know, with EB1, we see more of a push from the administration on STEM fields, you know, these emerging technologies, and getting people that EB1 that are, you know, maybe filing new, fresh 485s instead of just transferring their basis. So I do think there is some number to that. They don't necessarily have that. We don't necessarily have that data though. But yeah.
And the other thing, you know, yes, there are a lot of people that have both EB2 and EB3. So when we look at those together, right now there are 55,000 485s that are pending in EB2 and EB3 combined for India. So again, looking to those pre-COVID years, if we add up the number of approvals that came to EB2 India and the number of approvals that came to EB3 India, and kind of look at the average over those 5 years pre-COVID, it was about 9,386 average that got approved combining EB2 and EB3. So if we take that 55,000 pending and divide it by the 9,300 that may get approved, that narrows it down to about 6 years that it might take for EB2, EB3, the current backlog, the current pending 485s to clear up. But I think that average is actually high because there are 2 anomaly years in that, where the total approved in 2015 was 14,000. The total approved in 2018 was 10,000, but every other year was more like 5,000, 7,000, 8,000. So if we take out those anomalies, the average is probably closer to 7,000, or what we can expect for the next couple of years since we have no spillover. For the 7,000 number, we're back up to that 7 to 8 years. So I still think, even knowing that people have both EB2 and EB3, there's not that, it's not a vast majority that filed multiple 485s.
So,
you know, just looking at our cases, I think most people opted to do the transfer of underlying basis, especially for people that are jumping into EB1. When they're getting into EB1, it's a lot of the people have not filed a 485 yet because their date is in 2015, 2016, 2017. So I don't think there's that many who have EB2, EB3, and EB1. And the number of that have both EB2 and EB3 is a pretty small percentage, just based on what our firm filed in terms of people refiling when the date became current, and EB2 later.
So EB1, we can port the priority date. EB2, EB3, we can port that to an EB1 priority date. So EB1, you know, might fluctuate a little bit. You know, and I know EB5, Emily, isn't an easy option. It's a big investment, a big ask, but I mean, that's the only thing we've got current right now for every country of nationality. And I don't know how long that's going to change. Weirdly, they did not publish how many 485s are pending for any country for the EB5 set aside. And I talked to our friends over at WR, and they were like, wait, am I missing something? I said, no, I don't see it either. There are 485s that are filed. We don't know that number. But EB5 still remains current. I don't know how long that's going to be. I get it. I know that it's a big investment amount. I'm not saying everybody go file EB5 tomorrow, but for some people, it may be a good option. And you know, we can work on some of the age out issues. And there are a lot of progressive ideals with funding with the RIA. So reach out. That's something that may be an option because it's the only one that's current right now, unfortunately. And then, like I said earlier, I mean, there is a push, Emily, I think, from the administration on EB1, especially with STEM and engineering and emerging technologies, and you know, a little bit different. And my thought is act soon. We don't know what's going to happen in November. I'm not going to be a doomsdayer, right? But right now they're being pro EB1 for these technologies.
Yeah, and you know, with 55,000 people that have a pending 485 in either EB2 or EB3, We've definitely seen where USCIS doesn't follow first in, first out, where they've let green cards go to waste in some prior years. They've done much better about that. They claim when they published this data today, they took you to the 485 employment-based FAQ page that says they're doing their best to use up all the green cards. But for someone whose date is current or about to be current, what steps can they take to make sure that they're one of the few that actually can get the green card this year and don't get stuck in this 55,000 person wait?
Yeah, so I will preface this with the same thing I talk with everybody about litigation. If you want to try your routes, talking to your congressperson or filing an expedite request, do it. I don't see a lot of those work. And so what we've turned to is kind of a last resort choice for a lot of people, which is suing the government. And we've been doing that on some 485s. And there's, I always talk individually with people before we sue on these, because 485 litigation is a very interesting area of law. There was a lot of case law against it in 2021. We've kind of pivoted with our team to make that a lot stronger of a fight on the jurisdiction issue so the courts can look at it. There's been some case law back to USCIS's side, but we're still seeing some positive traction. I will say one of the recommendations Emily and I were talking about today, I had a U.S. attorney reach out to me and said, hey, we got this case. Our response is due this date. Here's 2 medical RFEs for your client. I sent those over. I think one of my recommendations for everybody is going to be that, we're getting the visa bulletin much earlier than we did under the Trump administration, right? We're seeing it first week, second week maybe of the month. We already have the June one. Here we are at May 14th. Once you have that, look at your situation and make sure your 485 is adjudication ready. What was your last transfer of underlying basis? Did you go from EB3 to EB2 and now you're going to be current in EB3? Maybe file a transfer of underlying basis back. Maybe get that 485J filed. Get that medical if it's expired. Now that we have that new policy to keep those valid indefinitely, get that done. But we have enough time now, right? Because I can't litigate your case until you're current. So we've got the June visa bulletin. If you're current under that, that would be my recommendation. Get your ducks in a row, and then prepare for litigation on these. And like I said, we're seeing good results. I think there are some room for the government to potentially defend these cases. I have a very in-depth conversation with everybody about the possibilities on litigation and what to expect, because 485 is a little interesting. But we're seeing good results so far, which is good, which I'm hoping continues.
So besides litigating the 485 to hopefully get that approval while the dates remain current for someone, what other areas are you able to litigate? What other delays are we seeing that litigation has been helpful in? Yeah,
so I will say one of the ones that we've hit a lot on is advanced parole, or even the initial EAD. I know there's not a lot, there's not a lot of new 485s, but even for the people who have it pending, that advanced parole extension is taking 7, 8, 9 months or longer. For some people, that EAD renewal is coming quick, but the advanced parole is not. We've been doing a good number of those for individuals. 221G and advanced parole. It is a very mixed bag of case law. The government keeps wanting to argue a 221G is a final agency action and therefore it's subject to concert non-reviewability. It's never been that way. U.S. Department of State does not treat it like a final agency action. The Foreign Affairs Manual doesn't treat it like a final agency action. But they're going to try to hide behind concert non-reviewability wherever they can. There's been some courts that have called them out for it. There are some courts that have taken the easy route and say 221G by the language says it's a refusal, therefore it's a refusal. I don't necessarily agree with that. We've been doing that because we've had these these 221Gs at admin processings that'll take. I talked to someone December of 2022, got a 221G, and it's still stuck. There's not a fraud concern. There's not, we see a lot. I talk to a lot of attorneys who see a lot, especially from Iranian males, right? Because of our the geopolitical climate surrounding Iran. We see that a lot. This in there. So looking at that, unfortunately, more denials, Emily. I mean, especially on the 485 at the field offices. I will preface this to say most 485s go very smoothly, right? If you've got a approved I-140, you don't have an inadmissibility, you were maintaining status before you filed, you have the job offer, most go smoothly. But we've seen a number, Emily, you had a consultation today about some weird situations with these field offices because you can't contact them and they don't really know what they're doing. We see some weird denials out of the field offices. We've taken up some of those. So we've got a couple of cases on PERM, knock on wood. Those are going to get us somewhere soon where we can do a lot more of them for folks, because PERM is ridiculous. What should be 45 to 60 days is up over a year. That's not okay. But if you've got delays, denials, look, not everything can be litigated. I will say that. But I'm happy to have a conversation and see what we can maybe come up with.
All right. Next up, concurrent H1Bs. So, if you're working for company A and you get a job offer with company B and you want to continue working for company A, company B can file an H1B that requests concurrent employment. It's just like a regular H1B. Everything's exactly the same, all the same documentation. It's just a matter of checking one box differently. Instead of change of employer, it's concurrent employment. And so you get that approval notice. You start working for both companies, which is great. I mean, you can and you can set the hours that you want to work for the second job. If you want to keep your full-time job full-time and then work part-time for the second company, even full-time for the second company, totally fine, as long as those hours are mentioned in the petition and the company is complying with all of the LCA requirements. You can do that. You can even have more than one. You can have multiple concurrent H1B approvals. So what happens when the main job with company A, maybe there's a termination there, maybe there's a layoff, or maybe you just decide you want to end with that company? What happens to the concurrent H1Bs? Because they were filed as concurrent, which means they're valid while the original one is valid. Is there any guidance on that, or what are we doing in that situation?
No, that's where concurrent gets weird, and that's not the only area that concurrent gets weird. Travel's another one, but concurrent employment on H1Bs, the Wild West of H1Bs. There are not these, the regulations don't address it very, very well. There's not all these policies like you have typical H1Bs. I can tell you what our firm's thought is that, concurrent H1B is kind of, for lack of a better word, subservient to the primary. And so you have to maintain that primary in order to maintain the current. If that primary ends for whatever reason, it's bad. In my opinion, the safest route would be to file a transfer, right, to go full with the concurrent employer. There is a very good argument, I think, that can be made that says we just need to amend the concurrent employment. I think that's a fine argument. I welcome that. I can only tell you what Emily and I and the rest of us here kind of think is the safest mechanism, which is the transfer. The same thing with travel, Emily. I mean, there's a big debate in the immigration law community. You go, you travel, you get your visa stamp for company A, you come back in, you get an I-94 with company A. Can you just pick up that concurrent employment again? Do you need to refile it? There's no guidance.
Yeah,
nobody knows.
There's no guidance at all, no information. I mean, it'd be great if you could get both visas stamped, but that I don't think is an option. You can only have one H1B in your passport. And then, of course, you're coming in and you're showing that visa that says you're going to work for this company. If you show them the other approval notice at CBP, they're going to look at you like you have two heads. They're not going to know what to do with that second approval notice. They can probably send you back home because why, you're claiming you're going to work for a company you don't have a visa for. Who knows? So there's just no guidance on that. Because of that, we typically recommend that once you re-enter on the visa stamped with company A, and if you want to continue to work concurrently with company B, to file another concurrent H1B petition that has that new I-94 number on it, your latest date of entry, just to be on the safe side. I don't think we've ever been tested in the situation where someone did not follow that and then ran into a problem at the 485 stage. But it's pretty, I don't want to say rare for people to do concurrent employment, but it's not as common to where at the 485 stage, officers even know what it is. I mean, there's been so many times where we take people for their green card interview where they've worked 2 jobs at once, and those officers are just bamboozled. They've never heard of that before. How can you work 2 full-time jobs at once? Like, come on, this is the real world. This is America. People can work 80 hours. It's okay, and it's legal.
I think post 2020, we've seen an uptick in concurrent, with people working remote, with businesses aligning their practices so people can work remote. We're seeing more concurrent because you have that opportunity. You don't have to be in 2 offices at once. You can work one during the day and work one in the evening, whatever you guys want to do on that concurrent that gets approved. But it is a gray area. I mean, we're gonna maybe take a conservative approach, but I feel better going with a conservative approach and not being risky in this instance.
Yeah, for sure. You don't want to be in a situation where you're finally at the 485 stage and they claim that work was done without authorization after you entered. Because working without authorization for 180 days or more makes someone ineligible for adjustment of status. Their 485 can be denied on that ground alone. So it's definitely something not to be too aggressive with until we get some actual guidance. Last topic real quick so we can get to everyone's questions on for those that end up getting a Cap-Exempt H1B. This is either with a university, with a nonprofit organization that's affiliated with a university, or that's a research organization or a government research organization. One thing to note on concurrent employment, if you have a Cap-Exempt H1B, you can have a concurrent H1B with a Cap subject employer and work full-time with the Cap subject employer while you're also on the Cap-Exempt H1B without going through the lottery. But what if you want to end your Cap-Exempt H1B work and switch over to Cap subject H1B? What does that transition look like?
Yeah, so if you want to go fully with the Cap subject employer, some people for profit, that's what they call it. You would have to go through the H1B lottery and go through that process in March of each year, get selected, get it approved so you can start with that company alone. So just keep that in mind. I like to use the phrase immigration planning, and it's kind of like estate planning, but for your immigration journey. So, think through, plan that out. If you're going to make a switch, that you're going to have to file in the lottery, get selected, get it approved, and then you can start on it.
All right, getting to some questions, and Vasafir has a question related to this whole transition from Cap-Exempt to kind of Cap subject. His situation for his wife, she has this non-Cap H1B, but the 6-year limit is coming up in August. So rationally, they applied for a change of status from H1B to H4 with the H4 EAD, because I'm assuming he's got an approved I-140. H4 got approved. Great. H4 EAD still pending. So she is now in H4 status. Her H1B could still be valid till August, but her status got changed to H4. What are the options for her to be able to work while she's waiting for the H4 EAD? I think the best option is our Margarita switch, automatic visa revalidation. She's got an H1B approval notice with the Cap-Exempt employer that's valid until August. I'm assuming it has an I-94 on it. Although she got the H4 change of status approved, she can exit the U.S., use even an old expired visa stamp, go to Mexico, come back in, show the H1B approval notice, be let back in H1B status, continue the H1B till August, and hopefully by then the H4 EAD gets approved. Then she can do the margarita switch right back around, go out, come back in on the H4 approval notice, because that has an I-94 as well. So automatic visa revalidation allows you to travel to Canada or Mexico less than 30 days if you do not apply for a visa stamp there. And as long as you have a valid I-94, you can use an old expired visa stamp or a visa stamp that's in a different category and still come back into the US. So that is one way to switch back and forth between H1B and H4 when you have those two approval notices with two valid I-94s, so that she doesn't have to lose her job opportunity waiting for this stupid H4 EAD to be approved.
He mentions too in the next message, can you do the H1B amendment and premium and do the new H4 EAD? Sure. I mean, you can with our Edicuni settlement do that. They should process them all together if your employer is going to do that. I don't want to go back to litigating H4s. I'd hope they kind of fix this, but we can't. We've done litigation for H4 EADs for these initial ones, and if we need to, I mean, I think filing in October, it's been what, 6 months, little over 6 months. Yeah, I mean, I think we can make a good case. If that's something you want to do, feel free to reach out to our firm. And I'm happy to try to connect with you on that if that's a route you want to look at. Emily Carthage has a good question. H1B approved for Texas work location. Amendment was filed and approved for California. Now he wants to move back to Texas because it is the best state out there. And then can we use the existing approved H1B for Texas without having to file anything? I would argue yes.
Yeah, there's no guidance here either. So we're just making stuff up as we go. But the idea of an amendment is that it doesn't replace the underlying approval. It's in addition to the underlying approval. So as long as you're going back to the same job in the same work location, same duties, same salary, and that petition has not expired, you should be able to do that. And I've not seen any negative consequences of anyone doing that, but there's no guidance that says one way or another.
I mean, yeah, I think the argument is, kind of a little bit different than what we discussed earlier. Here you are authorized to work. We know that. You've amended it, but there isn't any language in regulation or anything that gets rid of it. I mean, I guess if you wanted to be super, super cautious, you could do the margarita switch back to that Texas work location. I don't think it's necessary. I think that would be overly cautious, but, like to give you your options there.
Yeah. Let's see. HBK says, if I put in an application to upgrade from EB2 to EB1 within the next year, when can I expect to be current? My filing date is mid-2023. So I'm assuming that's the priority date, is sometime a year ago. I think that EB1 is going to be consistently backlogged by about 5 years. That is exactly what we were seeing pre-COVID, and everyone was crying and throwing a fit about EB1 being backlogged so long, and then COVID happened, and miraculously EB1's current for so long, but that's only because of the extra green cards. And on top of that, now we have more and more people that are filing in EB1. Plus they have earlier priority dates, so they're cutting in line, legally so, they can do that. So yeah, I think that it could be 4 years for the date to become current, since your date is a year ago. That's, of course, a guess. As we always say, we go wrong on predicting visa bulletin time and time again. It's practically impossible to get it right. Even the State Department clearly doesn't get it right. If you look at the October 2020 visa bulletin, they didn't know what they were doing then.
Question on, I just saw it and I lost it here. So H1B application is in process. Will there be a problem if I apply for a TN visa at the port of entry for a different employer? I'm going to assume in this question the H1B is your cap change of status. I'm assuming. I don't think you're going to face too many issues with the TN. The issues that we tend to see are if you have immigrant intent, you have the I-140, 485. I don't think an H1B is going to have issues with your TN.
Clevy26 says, spouse is on H1B traveling to India. Her passport expires in December 2024, but her I-797 is good till April 2027. And he wants to know if CBP assigns her an end date of December 2024 due to the passport, will this impact the H4 in any way? As long as she takes action before December 2024, no, it would not have any impact on you. So we talked before on here that if you are traveling in with a passport that's expiring before your I-797 or visa is expiring, CBP does cut short your I-94. So when you do get your renewed passport before it expires, you either need to travel again and come back in to get a new I-94 for the full period, or file an extension. So assuming she does either of those actions before December 2024, then your H4 is not impacted, because your H4 is valid till the end date of your H4 as long as the H1B is remaining in status. But if she doesn't take any action and she goes out of status in December 2024, that puts you out of status as well.
Question from Kay on Twitter. If we apply for EB2 NIW, can we switch it to an EB2 PERM or EB1? Yeah, you can always do that. And the reason I wanted to talk about this, EB2 NIW. So obviously we know, I'm going to not sit there and say EB2 NIW is this holy grail where you're going to get your green card. We talked about what the dates look like. Somehow Congress has decided you can be in the national interest, right? Be determined that you're in the national interest and you're still in the backlog. But there's a lot of positive ideas behind NIW. That's your I-140. So when we talk about layoffs and all, it's not going to be as jeopardized. You have a little bit more freedom of mobility with the EB2 NIW. You don't have to restart that PERM process. But yes, Kay, to answer your question, you can go EB2 NIW to PERM based to EB1.
Sarah Vanen has an interesting thought. Priority date's January 2015. So right after all these, 50,000 people that are already pending. He spent 12 years in the U.S. already, raised a family. Now he has an invitation from Canada for a work visa. Should he pivot and switch to Canada or wait it out in the U.S.? Well, based on this data, even though you're January 2015, it could be 8 years before your date finally becomes current and you can finally file the 485. So if it's a good opportunity in Canada, it may make sense to go there for 8 years. Remember, that priority date stays your priority date forever, no matter what. So 8 years from now, when it's about to become current, if you have a U.S. job offer at that time, any employer can file labor certification for you, file an I-140 for you, keeping that 2015 priority date, and then you can either consular process the green card, or if you've come back into the U.S., maybe you're a Canadian citizen by then, you can come back in on a TN and then file the 485. So you don't really have to choose one or the other. You could still technically do both. Go to Canada for 8 years, become a permanent resident there, get your citizenship there, come in on TN, have a new employer file the green card for you, or maybe by then you qualify to self-petition, or maybe you've worked for a Canadian entity that has a U.S. entity and you can get into EB1 before then. So you definitely have options to do that. So I just want to remind you that you're not permanently losing your opportunity in the U.S. if you choose to temporarily go to Canada.
Raj on YouTube asked a question I think, Emily, you and I see every year around this time in the summer. My employer has a 2 weeks notice period policy. If my visa is changed from L1B to H1B with a change of status with a new employer, do I need to comply with the company's policy? So I'm going to preface this by saying I'm not going to get into employment law or your employment agreement. But this comes up a lot. Even without the agreement, people want to be professional, give that 2 weeks notice. Unfortunately, when you do the change of status to H1B, on October 1st, let's say it's approved next week, October 1st comes around, you're on H1B, right? As of that day and ineligible to work for the L1 company. But kind of like our hypothetical earlier, margarita switch, we talk about this all the time. If you want to travel out, come back in, work for the L1 company for 2 weeks, let your H1B employer know, hey, I got to give them a 2-week notice. That works too. This comes up every year. Just know you can't do the L1 and the H1 together unless you do. You could maybe do the concurrent possibly, but I think you got to be very cautious and kind of plan that out.
SK has an interesting question. Has Congress ever said that the unused visa numbers actually expire? Why is USCIS not using those numbers? Unfortunately, yes, Congress has basically said that. So the way they designed the system, family-based numbers that go unused spill over to employment-based in the following year. Employment-based numbers that go unused do not. They're gone. So the only way we can use those numbers that went unused in the past is for Congress to pass a law that recaptures them. And they did do that once before in the AC-21 statute with Schedule A, when they carved out 50,000 EB3 green cards for nurses and physical therapists. They did do that back then once because the backlog was building. I think only Congress can do it again. I don't think it's something that the Biden administration or any agency can do. I think it does require congressional action, and obviously they're not doing anything. So we'll be holding our breath, waiting for that to happen.
Mauricio asked a question on YouTube that I, Emily, and many attorneys ask every day. Why are they not doing anything on 601A waivers? There is a lot of litigation on 601A that is going to meet it ahead, I think, this summer. Some of the district courts have been finding that there's not a jurisdiction because it's a discretionary benefit. Those are up on appeal, including one from our firm. It is up on appeal in the up in Chicago on 601As. There are a lot of people pushing this in court because 601A waivers are absurd. You mentioned 4 to 6 year processing times. That sounds about right on what they're doing right now. Just know, Mauricio, there's a lot of traction to try to get this fixed from a lot of people I have a lot of respect for.
Let's see here. Beeb says, what is the priority date? Where can I find it? I'm waiting for my PERM approval. So for you, it's actually going to, it's the day your PERM was filed, but you won't have any documentation of it until your PERM is actually approved. On the PERM labor certification approval notice, it will list the date of filing. It doesn't call it priority date, but it says date of PERM filing. That's going to be your priority date. When you then file your I-140 and get that approval, your priority date will be noted on your I-140 approval, and it will be locked in at that point.
Rohan on YouTube asks a question about the employer asking the employee to pay for the I-140 political asylum fee. This was hotly debated because if you look, the I-140 says employers. It was debated in the self-petitioning context. But the employer can have the employee pay for the I-140 fees, not the PERM fees, not the H1B fees, but the I-140 can. So yes, Rohan, it is legal for them to ask for that.
Hassia says, can my company refuse to file the 485 because I'm not in the PERM position yet? What should I do then? So you do need your company's cooperation to file the 485 because they need to include an I-485 Supplement J. In that Supplement J, the company is confirming that they are offering you the position that's on your PERM. They're not confirming that you're in that position. They're just offering it to you. This whole process is based on the job offer for the role you take when you actually get your green card, not when you file the 485. There's no requirement legally that you be in that role to file the 485. So if the company's refusing to do it, it's either because they've set their own policy that way or they're misinterpreting the rules, because there's no requirement that you be in that job to file the 485.
There was a question, gosh, I'm trying to find who asked it again, but they had asked that they had cousins coming to visit from India on B visa, can they, for about 2 months, can they continue their job in India with their Indian employer here in the U.S.? And the answer is no, not on B visa. There are a lot of countries that are having creating what are called nomad visas for this exact situation, where you are traveling, you're going to stay there short term, you're completely working for a foreign entity only. The U.S. does not have that. The U.S. Requires you to have work authorization, even though the job is completely overseas. Because you're working in the U.S. and you're sitting in the U.S., Rahul likes to say, "Where's your butt sitting?" That's his term of art here. You have to have work authorization. So no, they cannot continue their job here.
K from X says, if we ever apply for an EB2 NIW, can we switch to EB2 PERM based or EB1? Yes, absolutely. So if you do later have an employer that sponsors you for EB2 under the PERM process, you can also retain your EB2 NIW priority date. So you will have 2 EB2 approvals, one in NIW, one based on PERM. They'll both have the same priority date. And then if you later qualify for EB1, you can get that approved too and keep that same priority date. And you can go with whichever one or all 3 when it's finally time to file your 485.
Question from GS, because apparently we're gonna talk a lot about things that don't have guidance. His spouse is on H4 EAD. If he goes for H1 visa stamping and gets a 221G, can she continue to work in the U.S. while he's abroad waiting for the 221G to get adjudicated? At GS, this is another area where there's not good guidance. My argument, if I were to be representing you, would be that she has a valid H4 and a valid H4 EAD and can continue to work. The counter to that is that in order to maintain H4 status, the H1B spouse has to be maintaining H1B status. So you kind of have 2 things that are at a head here, and you're going to really have to kind of cost-benefit analysis. This would be a situation, I think a lot would depend on where you are at, maybe in the potential green card process. And potentially, if you go the route of having your wife work, have her travel before filing a green card, because you want to make sure she's properly maintaining H4 status before filing the 485.
Yeah, for employment-based 485, there are a lot of things that can be cured by traveling before you file the 485. So if you've had a prior status issue, if you've had prior unauthorized employment, anything but unlawful presence, well, not anything, but status violations and unauthorized employment can be cured by traveling and coming back in before filing the 485. Unlawful presence, where you've overstayed your I-94 for more than 180 days, cannot be cured simply by traveling and coming back in. So yeah, travel is a great idea there. Rohan asks, is it legal for the employer to ask the employee to pay for the asylum fee during the I-140 process? I believe it is. I don't think there's anything in the fee rule that specifically requires the employer to pay that asylum fee, because even before the fee rule, the employee could pay the I-140 filing fee. So now we're just adding an additional fee on top of that. I think the company does have the right to ask the employee to pay for that.
Rajesh on YouTube, I filed 485 in June 2023 with his medicals. Never asked for biometrics. What are the chances that it'll get approved before October this year? My priority date is current since October 2023. I'm hopeful, cautiously optimistic. If you want to take action, I'm happy to talk about litigation options, whether it's a good option for you or not. It's going to be kind of dependent on different factors. That's why I like to have one-on-one conversations about litigation. So feel free to reach out on that, because there's no guarantee it's going to get approved in October, before October.
Bloodhound says, how many EB1s does India get each year on average? So I don't have the exact figure, but I do have all the data on immigrationgirl.com. I've got one of my, I would say recent, but it's actually from September 2022. It's a post called Why Can't Anyone Predict the Visa Bulletin? I've got a chart there that has every year how many EB1, how many EB2, and how many EB3 were approved for India specifically. So if we look, and this goes all the way back to the year 2000. So if we look at the turn of the century, 2,400, 3,000, 2,800, 1,200, 2,000 every year. Fast forward 10 years to 2010, it's closer to 6,000, 5,000, 9,000, 9,000, 12,000. Keeps going up from there. And then right before COVID, it was 10,000, 9,000. 2020, 17,000. 2021, 30,000. 2022, 21,000. So obviously those last couple of years were due to the extra family-based numbers. So right prior to that, it was over 10,000 a year. And I think, where did we do the math? There were 16,000 pending for EB1 India.
Yeah, I've got it. Hold on. I've got it up on, let me pull it up here. I've got it. I was going to find which tab it is. EB1 India is 16,453 with priority dates ranging from before 2013 to 2022.
Yeah, so that's definitely more than what we were seeing in the years coming up to COVID. And because of the Biden administration kind of opening up EB1A more based on for STEM people and just being more friendly to EB1A, we just keep seeing more and more people. More people are considering the option of going overseas for a year to work and then going under EB1C. Or some people already worked abroad before they came to the U.S. in the managerial capacity. And now in the U.S., they've got that managerial role with an affiliate of that same company and are qualifying for EB1 now. I've filed a number of those this year. So yeah, more and more people are definitely opting for EB1 because obviously EB2 and EB3 are not great.
PM and SAPTA kind of addressed both of those. PM asked about any idea why I-131 AP requests are taking so long, and SAPTA asked about kind of similar, I-131 6 months ago pending, and EB2 485 is current. What are the options? So PM, I have heard from an attorney that I am close with that was in a meeting with some of the big wigs with USCIS, and they feel every advanced parole requires them to exercise discretion, and that every I-131 request requires them to utilize that analysis of discretion. I don't know what that entails. I wholeheartedly disagree with them on that. I don't think there's any discretion in a 485 I-131, maybe on the DACA side, but the 485 side, no. But that was their excuse for why it's taking so long. Sapta, to your point, we have litigated I-131s. 6 months is about right to push on that. And also, if you're 485, depending on the situation, I'd be happy to chat about either. Let's get you trying to travel here. I know you've got travel plans, you said. Again, our email address, info@RN Law Group. I'm happy to talk to folks about that.
Robbie has a frustrating situation. His H1B extension plus the spouse's H4 and H4 EAD were all filed together. The H4 extension got an RFE and the EAD was denied because they said no supporting documents were submitted, even though the attorney submitted the supporting documents. What do you do in that situation? I would refile the H1B extension and the H4 and the H4 EAD all in premium processing, assuming your I-94s have not yet expired, which is why it's so important to always file early. Yes, I would just refile it all and not even mess around with having to do a motion to reopen that's going to take 6 months to process, and then they'll claim that, oh, you didn't provide proof, and they'll just dismiss it. The the service is being really terrible with motions to reopen right now. They're just denying them without even any analysis, not even looking at what you submit. It's really frustrating.
Chilika on YouTube, good question here. Tech lead for a Fortune 500 employer, LLC supporting the U.S. government and can get strong recommendation letters, making $500K the last 4 years. What are my EB1 chances? You know, I think you've got potentially some good options under EB1A. You know, it's hard to talk generalizations about EB1A because EB1A is going to be so unique to each person, but also potentially consider EB5. If, you know, you're with the salary you're talking about, you may have that option available to you as well. And like we said at the top of the hour, EB5 set-asides are the only thing current for every category. Department of State talking about retrogression for EB2, rest of the world. I think people are going to be starting to push their Congress people, Emily. I mean, if we're going to see it get worse before it gets better.
Yeah. SPG says, I was laid off April 5th. My current status is H1B, but I also have the GCEAD. What happens if I don't get a job before the 60-day grace period? What steps are to be taken to go to the GCEAD status? Well, it just happens automatically if you don't file anything for your non-immigrant status. So you can definitely do that. Safest to do it if your I-140 is already approved and you feel confident that your 485 is a clean case and you don't expect any issues. Always nice to have a backup plan of the underlying non-immigrant status, but for a lot of people, they can safely rely on the GCEAD, forego the H1B status. But remember, with the GCEAD, there is no 60-day grace period like there is for an H1B. Technically, for the green card EAD, for the green card itself, you need to always have a job offer that's in the same or similar occupation that your 485 was filed for. So you definitely should reach out to a qualified immigration attorney to understand what the consequences of not having a job are when you are leaving your H1B status and trying to rely on the green card EAD. You also may want to consider filing a change of status to B2 if you get to the end of your 60 days and don't have that job offer. I know it's counterintuitive to do that when you have an approved I-140 and a pending 485, but USCIS, they just retweeted again today what the options are when you lose your job, and specifically says, yes, having a pending or approved I-140 should have no impact on your change of status request. So that should be the same for the 485, just to have that as a kind of backup plan. But yeah, it's definitely a tough situation to be in.
I want to take one here real quick. Vivek asked, will premium processing of concurrently filed H1, H4, H4 EAD hold for the foreseeable future? Terms of the Edicuni settlement expire in January 2025. Vivek, thank you. That was on my checklist tomorrow because that was burning my in my brain when that expired, so we could start looking at it. I think a lot's going to depend on November, Emily. I mean, DHS doesn't want to bind itself to a future administration if there is a change, and we'll have to see. Remember, that was all going together swimmingly until 2019 is when they changed it with the biometrics and separating them out. So I think we'll see in November what it looks like with the election.
All right. Well, I think we are out of time for today. Thanks so much, Stephen, for joining us this week. And thanks, everyone, for tuning in. We'll be back again next week on Tuesday at 5 o'clock Central Time. In the meantime, you can always set up a consultation with either of us or any of our attorneys here at Reddy Neumann Brown by going to rnlawgroup.com. And we will see you next week.